Okay, sorry everyone for the delay. There was some kind of strange background music, but we've seemed to resolve. Okay, so good morning, everyone, and welcome to this morning's Guardianship seminar. I'm Malkie Scher. I'm an attorney here at the Moskowitz Legal Group. We're a firm that specializes in estate planning, elder law, special needs planning, and guardianship. So how we're going to run today's seminar is I'm going to go through, let's just mute that music. Okay, so I'm going to go through some information for everybody, and then I'm going to allow some time at the end for questions. I did run a seminar in December that a couple of you may have attended. It will be similar to that, although I have made some changes, but the questions at the end may be very different. So it may be worth it for you to listen to it, even if you've listened to a prior seminar, because maybe the questions at the end could be helpful for you. Okay, so let's get started. Sorry, I'm just letting somebody in from the waiting room. Okay. Okay, so hi everyone. I just mentioned that I'm Malkie Scher. So I, in particular, at our law firm, I do special needs planning here and guardianship. I help navigate and I help point families in the right place so that legally they can make sure that their child who has an intellectual or developmentally disability is set legally, is set financially, and that their future is hopefully taken care of. And if there's anything that I can't do for them here at my office, I have built a lot of connections where I try to connect people with the right people. But my main thing is special needs planning and guardianship. I do also have extensive experience in representing parents and their lawsuits against the Department of Education. So these are the topics that we're going to be discussing today. Just want to click this to the right. All right, just letting some stragglers in. Okay, so these are our topics for today. So the first is we're going to discuss what is guardianship. Then we're going to go through some common scenarios where guardianship arises. Then we're going to be discussing, is guardianship right for your child? I'm probably going to keep using the word child, but really it does not have to be for your child. You could be seeking guardianship for a loved one, or you could be seeking guardianship for someone else as well. I just think I'm just going to keep using the word child because I think a lot of people that are attending today are parents or are providers that are looking to share this information with parents. So I want to make sure someone's not waiting in the waiting room. Okay, next we're going to discuss some alternatives to guardianship. And then we're going to discuss how to get appointed guardian in the New York surrogates court system. I'm not going to be going through every single step of the filing process, but I do want to give everyone that overview. Okay, so what is guardianship? So when an individual turns 18 years old, sorry about that, when an individual turns 18 years old, the law now presumes that they're able and capable of making all of their own healthcare, financial, and legal decisions. Now, a child who has an intellectual or developmental disability oftentimes will continue to require their parents' assistance throughout adulthood. Without guardianship in place, you may encounter challenges, which would make it difficult for you to continue assisting your child in that way. So guardianship, and I'm going to keep referring, I might refer to it as guardianship or 17A guardianship, but guardianship is a legal tool designed to empower parents to make decisions on behalf of their children with an intellectual or developmental disability. So let's talk about some of those scenarios of when it comes up. So these are the three biggest categories where guardianship is used for, but there's many others. So the first topic where it comes up all the time, and this one is quite important, is with healthcare decision-making. So a lot of parents don't realize this, but technically when your child turns 18, your child's doctor is no longer authorized to speak to you about your child's health. They're just really not allowed to do that anymore. So while your primary care physician, who maybe your family has been seeing for the last 20 years, they may afford you some leeway. They know you, they understand your situation, they understand that your child is more dependent on you. They may afford you that leeway and keep speaking with you. But if your child has to get a medical procedure and go to a medical facility, or if your child has to see some kind of specialist, or maybe if you're switching doctors for some reason, the new doctor you're seeing is almost definitely going to require guardianship to be in place before you start making decisions on behalf of your child. So you don't want to wait until like the day of a big procedure to realize that you needed guardianship to be in place in the first place. So parents always ask, like, when is a good time to do guardianship? As close to 18 as possible. Many counties will allow you to file at 17 and a half or a few months before you turn 18. You could still seek guardianship at 20, at 25, or at 30, but doing it preemptively could really avoid a lot of emergency situations. We have unfortunately had parents call us from a hospital on the day that their child is supposed to receive a big procedure, where they say, oh no, the doctor's not willing to do the procedure. We needed guardianship in place. Could you quickly get me guardianship for tomorrow? It's not possible. Guardianship cannot be done in one day. It's a little bit of a process. We do try to streamline it at our firm as much as possible, but it's not the kind of thing that could be done overnight. And it's really good to do it preemptively as opposed to waiting for that kind of scenario to arise. Next is with financial affairs. So this is mostly coming up in a scenario of, let's say your child comes into a large sum of money from like a settlement, inheritance, maybe some kind of income. Without formal guardianship in place, a parent's going to face challenges navigating that money on behalf of their child. The third type is for residential or housing decisions. So let's say an individual needs to move to a new living arrangement or a group home, and formal decisions have to be made regarding housing. A lot of facilities are going to require that guardianship be in place in order for parents to make those decisions on behalf of their children. It also comes up in a lot of random situations where I learn more about that every day from parents who tell me. So for instance, I had a parent tell me that she went to go renew her child's passport, and she went with the whole family. They were renewing everyone's passport. One child seemed to be a little bit lower functioning, and the passport office just said, we're not renewing the passport, you need guardianship. So that could either be a minor deal where, okay, we'll just, get guardianship, come back in a few months, or it could be a huge deal. Let's say your whole family was planning on taking a trip next week, and now one of your children don't have an updated passport. So guardianship is the kind of thing to do preemptively, not once you find out that you needed it. Okay, not going to go through the whole legal foundation here. I just think that everybody should be informed. There are multiple types of guardianship. If any of you have started to do your own research, or if you've been talking with people, you may have heard of the different types. The type that we're talking about here today, which would be relevant to all of you, is called 17A guardianship. It's found in Article 17A of the Surrogates Court Procedure Act. Okay. Is guardianship right for your child? This is something that comes up every single day at my firm, and it's probably the number one reason why parents are calling, because they heard about guardianship, someone told them they should start thinking about it, and they're kind of stuck at this point of, I understand what it is, I understand why it's necessary. Now is my child somebody who I should be seeking guardianship for? And it's a great question. And I've really been discussing this a lot with parents, and I've been learning a lot more, speaking with the courts and hearing the different nuances of what the court is really looking for. So this is what you should think about if you are trying to decide whether your child is the right candidate to have a guardianship. So if your child faces challenges in making decisions due to an intellectual or developmental disability, then 17A guardianship may be necessary. Now, it's very, very important to keep in mind that for the type of guardianship we're talking about, they have to have a diagnosed intellectual or developmental disability. And it needed to have started before the age of 22. So sometimes parents will call me and they'll already start off the conversation and they'll say, my child is extremely high functioning, but they have bipolar disorder, or maybe they have schizophrenia. It doesn't mean that it's entirely impossible to get guardianship, but it's likely that this type of guardianship is not going to work because the court is not necessarily going to see a mental health diagnosis alone as a legitimate intellectual or developmental disability with regards to this type of guardianship. So just to know, so that's the first step, you have to have a diagnosed intellectual or developmental disability. The second is they actually have to lack the capacity to make their own decisions. If your child really is totally understanding everything that's going on and they are really basically functioning without you, but you just kind of want to get guardianship, this is for sure not something that you should be pursuing because you're not going to get approved. Okay, so some things to help you think more about whether it's right for your family. So evaluate your child's abilities in areas such as communication, self-care, social skills, and overall adaptive functioning. You could speak to their healthcare provider, their teachers, their therapists, their care managers. Presumably, they all will be somewhat familiar with guardianship and may be able to guide you better. It's a great idea to seek a new psychological evaluation for your child. You may already have one if you're trying to get approved for other types of services. And if you actually are trying to file a guardianship, you're likely going to need an updated evaluation anyway. But if you have an evaluation to look at, you could give that to somebody and ask them to review it for you and say, okay, now you're looking at an evaluation of my child. Could you help me determine whether my child would get approved for guardianship? If you present that to a lawyer, hopefully they'd be able to look at it and say what your likelihood of getting approved for guardianship is. But you should be, looking at your child's really ability to make everyday decisions and consider their, do they understand consequences? Could they express preferences? If you're already describing to someone as my child is very high functioning, right? Whatever that means, that's very hard to define. But if that's something that you are saying to people, it's probably going to be hard to get guardianship. So these are the kind of things that I found that the court is looking at. Can the individual travel independently? Can they administer their own medication? Could they attend doctor appointments on their own? Could they schedule doctor's appointments on their own? Would they know that it's time for them to go to the doctor? Like, would they realize maybe that something's hurting them a lot and that it would be a good idea to make a doctor's appointment? Could they run errands independently? Could they live on their own? Do they have a concept of time? Do they have a driver's license? Can they attend college? And can they hold down a job? If you answered yes to all of these, certainly cannot do guardianship. If you answered yes to some of these, that would have to be something that's more of an assessment. But the more things you're answering yes to of those, the less likely it would be that a court would approve a guardianship. So now what? Let's say you have decided, sorry, I'm just switching my slide. Okay. Let's say that you have decided that guardianship is appropriate for your child. Great, we could talk about how to go through with that in a second. But let's say you've decided that guardianship is not appropriate for your child, but they still need your help, right? Let's say you decide that your child understands a lot of what's going on. They really are able to navigate a lot of the world independently, but they really need your help. They still have some gaps in their understanding, and they need their parents' help. They don't want to go to the doctor completely by themselves and be making all their own medical decisions, even if maybe they do have the capacity to do so. So how can parents still support their children and be able to give them the assistance they need without pursuing a guardianship? So there's two main alternatives that I want to discuss. The first is called supportive decision-making. I'm going to be quite honest, I don't know a lot about supportive decision-making. I do know what it is, though. I don't think that you'll find many attorneys that know a lot about supportive decision-making, because it's not the kind of thing that you would be setting up with a lawyer. But I'll explain what it is, and if you do feel like this is something interesting for you, you should explore that avenue. So supportive decision-making basically involves a collaborative approach with a support network. Where basically the individual with disabilities themselves picks a network of supporters. This could be a doctor, a mentor, a teacher, a parent, an older sibling, people that they would typically look to for guidance. And this would be called their support network. Then the individual meets with their support network and comes up with an informal agreement of how they're going to make their decisions. I don't fully know how practically that plays out, but I have heard from people that this informal process works for them and that they have been able to find some information on it online. The downside of that is that it kind of just helps with the talking out part when your child just wants someone to talk out their decisions, but it doesn't actually give anybody the power to help them make the decision. Like if you were going to a doctor's office, you can't provide them with your supportive decision-making outline and say, oh, my child was supposed to listen to this outline. It doesn't really do anything in that sense. It just kind of helps plan for your child. But the other alternative I want to discuss, we find here at our firm that this is really the alternative that has been the most helpful for parents. I want to speak about that for a few minutes. I want to talk about this packet that my firm has created that we've been working on. I don't know if I'm in the right view here, but this packet that my firm has been working on, which we call an advanced directives packet. We've basically compiled a few different documents. One is a healthcare proxy and living will, the other is a power of attorney, and the third is a HIPAA release form. We've altered the documents a little bit, and we've tried to make a very user-friendly packet for parents and their child to be able to go through with very specific instructions on how to use it and how to fill it out. I've been doing a lot of these packets lately with families, and they either come into our office or we speak about it on the phone, and I explain how to fill out these documents. I always have the individual come themselves. They typically have a lot of questions for me. And we talk about this packet, make sure it's filled out directly, and I explain to parents and the individual themselves how they could use this packet to their benefit. But just so that you can understand, this packet will give parent or whoever the child designates as their agent the ability to assist with medical decisions and with financial decisions. The biggest difference between doing one of these packets and guardianship is that guardianship is really very strong and much more absolute, while these documents are great tools to help break down the barriers between, let's say, you and the bank. If you bring a power of attorney to a bank, they're going to speak with you more freely. But if your child disagrees with any of your decisions, if you only do a packet, your child's decisions are going to prevail. But if you do guardianship, you now make the decisions instead of your child. So the best way to understand that is, let's say you're sitting at the doctor's office and the doctor says, this child needs to get a certain procedure. Let's say the child says, no, I don't want to get the procedure. If you have guardianship and you say, yes, my child needs to get it, the doctor's going to only take what you said into account, and they're going to do the procedure on the child. But let's say you just have, healthcare proxy or a power or a HIPAA release filled out, and the child says, I don't want to get this procedure. And the parent says, well, you really need it. The doctor's only going to listen to the child in that sense. So guardianship really is a lot stronger. So a lot of parents feel more comforted in getting it, but it doesn't mean that you're able to get it. Because if your child is much higher functioning, you want to look at doing one of the alternatives to just help you as much as possible. I hope that was clear. If anyone has more questions about that at the end, we'll definitely talk about it more. Okay, how to get appointed guardian in the New York surrogates court system. It's definitely important to note, and parents ask me this every day, do I have to hire a lawyer? You do not have to hire a lawyer. You could do this on your own. You go to the surrogates court where you live, or it's really where your child lives. If they don't live with you, you go to the surrogates court where they live. You show up and you say to them, I want to pursue, 17A guardianship. You speak to the clerk. They could give you the required forms. I have seen parents successfully do this on their own, but very often it becomes complex pretty quickly, and they do find that it was much better to ask a lawyer for assistance. But that being said, there are definitely certain type of parents out there that are extremely organized, maybe have a little bit more time on their hand, who are very, very savvy with this stuff, and you really could complete this on your own without a lawyer. It's just that we have had to take over multiple cases for parents that try to do this on their own. They quickly became overwhelmed. They didn't really want to deal with this, and then chose to hire us afterwards. But this is the process nonetheless. Okay, so these are the 3 steps. First, you have to gather all the documents. So a big component of the documents that are being gathered are documents that prove the need for the guardianship. So this includes medical and psychological evaluations. There's also various court documents which have to be completed and often signed by different family members. If you chose to use our firm, we try to streamline this process as much as possible. We try to draft a lot of the documents for you. We try to communicate with the doctor's offices or psychologists with you to help you gather those documents as efficiently as possible. Once the documents are all gathered and ready to go, then the case gets filed with the courts. The court's going to review the information. They typically do have some follow-up questions, or they sometimes ask for additional information at this stage. Something that also gets done during the court review is a background check on the guardian. This is a little bit of a more time-consuming part because it does take a couple of months for the court to get the background check completed. The 3rd step is the hearing. So you likely will need to attend a hearing. This is something that different counties are doing virtually. Some of them are doing it in person, but your child will also have to go to the hearing with you. And basically what the judge is going to be looking at is A, does this individual need a guardian? And B, is the person asking to be guardian an appropriate choice? If you used our firm, we go to the hearing with you. Something else that I didn't mention about the whole process is just the concept of a standby guardian. Parents feel very comforted knowing that, when you're filing your guardianship papers, you also get to choose if you want to have a backup guardian. We call it a standby guardian, somebody who would step into your shoes if you were no longer able to act as guardian. So reasons people may not be able to act as guardian any longer is, it could be that somebody passes away, but also just maybe if somebody becomes elderly, or if somebody just doesn't have the room on their plate to be guardian any longer, a standby guardian could step into their shoes and take the guardian's place. So there's one more point that I want to talk about, and then I'm going to take everybody's questions. The way that we'll do the questions is if you go to reactions at the bottom of your screen, reactions, I think you click reactions and then raise your hand. And I have my colleague here that's going to be monitoring the computer. And then she'll unmute you when you raise your hand, and then you'll be able to ask your question. But one last point I want to talk about, because as I mentioned, I don't just do guardianship, I also do special needs planning. So I want to talk about the special needs planning or estate planning portion just shortly. So while becoming your child's guardian or choosing an appropriate alternative, is an important step in ensuring your child's medical and financial security. As a parent of a child with special needs, you should also take extra care to guarantee your child's financial security upon your passing. So what does this mean? So a lot of your children are probably getting some kind of services or government benefits, and many of those services have financial requirements. So what parents don't realize is that even if you're careful to not keep so much money in your child's name right now, upon your passing, your child may fall into a sum of money, which could jeopardize their government benefits. So it's very important, when you are starting to sit down and think about your finances and think about the future, that you do sit down with an attorney that does estate planning or special needs planning and talk to them about how you can plan for the future. How you could create a will, maybe set up something called a special needs trust, and just make sure that you have done your estate planning properly to ensure that your child's benefits are never jeopardized. Okay, so thank you everyone so much. I'm gonna just leave this last slide up for a little bit so you guys could see my contact information, and then we're gonna take questions. Please feel free to contact us if you have any more questions. This is my email. I think everyone that's attending here, I had emailed you the Zoom link before. That's my email address. So you could either reply to that email or you could email me separately. And this is my phone number with my direct extension. Okay, thank you very much. We'll now take questions. First, does anybody in the room have any questions that they want to ask? Okay, so I'm going to repeat your question for everybody. We're good. Okay, so we have a parent in the room. Well, just 1 second. We have a parent in the room that had a question. Her question was the cost. How much does it cost to do guardianship? If you're doing this process on your own, the filing fee is pretty low. I think the filing fee is typically $20. And then there's a couple of other fees you have to pay for too. One, to get certificates of guardianship afterwards. The fingerprinting also may cost like $10 or something like that. But it's not such a high cost process. The cost of hiring an attorney varies. We really, really try to keep it affordable for our families. At this point, we are charging a flat fee of $1,500. We would have to charge more sometimes in very specific scenarios, but at this point, we are really trying to stick to the one-time flat fee of $1,500. Okay. We're unmuting a participant now. Okay,
And my
you're
question is,
unmuted. You could ask your question.
if somebody starts the process on their own and then sees that they need help, does that make it more difficult for the parent or for your law firm? Or does it just not make a difference?
Okay, I'm just gonna pause you for a second. Here. Yeah. Okay, I heard your question, but unfortunately we have some background music. So I'm going to repeat your question for everybody. I don't know how to get rid of the background music, but your question was, if somebody starts the process on their own, right? And then they choose to hire an attorney, or maybe if they choose to hire my firm, does that make the process more or less more difficult for us, or does it make it easier for us? I just unmute her for a second so she could confirm I said it correctly.
Yeah, that, but also would it make it more difficult for the parent in any way?
And would it make it more difficult for the parent in any way? We typically don't change our pricing. We typically keep it as a flat rate of $1,500. It's quite low. This is not our moneymaker at our firm. But I would say it doesn't usually help me that much if a parent started the process on their own, unless they really are so far into the process. So if the parent, let's say, started filling out some of the paperwork on their own, And then they send it to me, and they started like 6 months ago, and then they send me some paperwork. Like typically I'm just redoing all the paperwork anyway, because the parent didn't necessarily fill it out exactly the way that the court wants it. You also run the risk of the documents expiring. Typically, the documents expire after a year. So sometimes the parent will come to us and say, okay, I got this doctor form filled out, and maybe the doctor form was not filled out correctly, so we have to help redo that. Or maybe the evaluation they did was done like 11 months ago, so like it's about to expire, and like we're not going to be able to get the rest of the documents done in time to file. So I would say if they're still at the gathering document stage, it's not really helpful for me at all if the parent started it before. I don't think that's necessary. Like if the parent's choosing to hire a lawyer and the lawyer is taking over the process, I don't think that's affects the parent really, whether it's more or less helpful. Like once you're paying a lawyer to handle it, I think because that was your question, right? If it's more or less helpful for the yeah. Okay, sorry, I can unmute her. Oh no, it's not Ava. Sorry. Okay, so sorry, just to go back here. If you hire a lawyer and you're at the gathering document stage, I would say it's probably not more helpful for the lawyer that you already started filling out the documents. But I have had some parents reach out to me where they're much closer to the hearing stage, and they already filed their documents. The court's already reviewing the documents. Maybe the court has just a couple of changes and they're actually going to a hearing soon. I have taken over at that point where maybe it's a little bit easier because the parents already filed the documents. Okay, so I hope that answers your question. If it doesn't, feel free to raise your hand again.
Someone asked what documents are needed.
Okay, so I don't really want to go through that whole list just because it takes quite some time. But anybody is welcome to call me and we could go over the process a little bit more in depth. But there's a bunch of different documents needed, some of which you could gather on your own, some of which somebody will be, if you hire my law firm or any other law firm, they might be drafting for you. But there's a bunch of different documents that would be needed for the process. Okay, now we're unmuting someone. Good.
Hello, thank you for doing this. I'm wondering if there's an age where it would be easier versus harder to start this process.
Okay. So the question was, is there an age? I'm assuming the age you're talking about is the age of the individual themselves, not the age of the
Correct.
parent. But is there an age? What'd you say?
I said correct, yes.
Okay. So here, just mute it. Really horrible background music. So is there an age that's easier to start the process? I really believe that starting the process closer to the age of 18 is a great idea. Any parent that calls us after the age of 17, we'll start the process for them. And some counties will allow you to file the case a few months before their child turns 18, which could be helpful. If you want to wait until your child's a little bit older, you're welcome to, but you might run into some scenarios before. And like I was saying, it's really a lot better to do this process preemptively rather than waiting for a specific time where you now know that you for sure need guardianship for that thing. If you already know that your child is the type of child to need a guardianship, it would be a really good idea for you to just start the process close to when they turn 18 years old. Okay, just let's unmute them. I want to make sure I want to make sure I answered your question. Did I answer your question?
You did, thank you. I also had a question, what about like when it's a foster kid, when it's not your biological kid or your niece that you're talking to raise from a different country? Like, is there an age that it's better for or not? But I think you answered it pretty well.
Okay, so you just brought something else up, and I know this wasn't your question. You were asking about like a foster parent or if a parent lives in a different country. I know this wasn't your question, but it was a good question that it made me think of. Somebody asking to be somebody's guardian does not have to be their parent. Their parent is just kind of like the obvious choice. And if the parent is not seeking to be guardian, then the court is probably going to want to know why. But other individuals could also seek guardianship over someone. as long as they were the appropriate person to do so. Okay. So let me see if she has- Ready? Okay. Any other questions? Okay. Okay, does anybody have any other questions? Someone wrote one in the chat. Can you read it to me?
Is it possible to apply for co-guardianship of father and aunt?
Yeah, they could hear me, right?
Yeah.
Okay, yes, it is definitely possible to apply for co-guardianship. People do all sorts of arrangements with co-guardianship. Someone's question here specifically was about if a father could be co-guardian with an aunt. It's perfectly permissible, but again, anytime one of the parents are not seeking to be guardian, the court will want to know why. So it might require some additional documentation, but an aunt could seek to be guardian and there could be co-guardians as well. Okay, what does that say?
Can you obtain the documents online instead of going to the surrogate court? Could you submit documentation online?
Great question. Can you, so first, can you access the documents online? Yes, you can access many, you can access all of the court generated forms online. Sometimes there's just other documents you have to submit too, but the basic documents you have to submit, like a petition, and some other documents related to that could be found online. But your question about filing it, I don't know of a way that a parent could file online. There might be a way. As a lawyer, I do have access to an e-filing system, which some courts allow me to use and some courts require me to mail it in. But parents that are usually doing this process online typically have to go in person or at least call the court and ask them. I'm not as familiar with the parents doing it on their own. Usually they kind of just figure that part out, but I know that parents typically like to go in and talk with the court directly, but I don't think there's an e-filing system for parents. Okay. Next question. Okay, can ask your question. Sure. I know there's background music to the part, but I don't even hear you speaking though. Do you want to write it in the chat? Okay, sorry, Pearl, I can't hear you, but anybody could write the questions in the chat and we could read it from there. Sorry about the background music. Yeah, okay, so do it. Okay, let's go to the chat. Okay. Can you repeat?
Could you repeat the 3 forms needed for the advanced directive packet?
Sure, okay. So it's not about the 3 forms that are needed in the advanced directives packet, but it's the 3 forms that we've included in our advanced directives packet. One is a healthcare proxy and living will. Those go together. The second is a power of attorney, and the third is a HIPAA release form. So we've included these packets. If you want to just know what the packet looks like, when you open it up, there's a welcome letter. It really explains how to use this packet, what the purpose is. There's a section that talks to the parent, and there's a section that talks to the child or the individual themselves. Then we have all the body of the documents written out, and then we have instructions on the side. That's what the packet looks like. Okay. Okay, there's Pearl's question from before, but did we skip? Yeah, with co-guardianship.
With co-guardianship, does either guardian have full control on decision-making power, or can one guardian veto or override the other?
Great question, excellent question. I think everyone was able to hear it, right? I don't have to repeat it. So with co-guardianship, each guardian has equal decision-making power. No one has more power over the other. So first of all, you don't both have to be present in order to make a decision. So meaning if one guardian is taking an individual to the doctor, that one guardian will just be able to have free reign to speak with the doctor, to make decisions. You don't have to call the other guardian on the phone in order to get their permission. In terms of one vetoing the other, It's not really like that. If the guardians are not on the same page, I would say they should not be co-guardians. So sometimes this comes up when parents are divorced and both parents are very involved in the child's life. So sometimes if parents are divorced, they can have a great relationship, and it would make sense for both parents to be co-guardians because both parents are kind of equally involved. And they both want to be able to be guardians, and that works out great. But if the parents don't have a good relationship, then they should not seek to be co-guardians because you will confuse a lot of scenarios. So for instance, if one guardian tells a doctor, we want to do this procedure, let's go ahead. But then the other guardian calls up the doctor and says, no, we're absolutely not doing this procedure. You're just going to delay the process. You're going to confuse the doctor. They're not going to be sure which guardian to listen to. So I wouldn't say that there's necessarily veto power. I'm sure there's some kind of recourse that can be done if a guardian is making horrible decisions about how to remove them from that position. But that could probably get a little bit messy. So if you know beforehand that two guardians don't necessarily get along, I would not suggest that they act as co-guardians. It will slow down the process and end up harming the individual that you're trying to help. Okay, next question.
Does the packet cost the same as the service you provide?
Absolutely not. The packet costs $500. And that price is the same whether you come into the office and sign the documents with us. It's not you who's just signing the documents. These are really the documents that belong to the individual, the individual themselves. It's their documents. They come into the office, they could sign them with me. There's some other signature spots for the people that they're appointing as their agents, or we could do it on the phone. This does not cost the same amount because this is more of a one-time thing, although you're always welcome to call and ask follow-up questions. But we charge $500 right now for the packet. We're going to try to stick to that price. Okay, next
For
question.
parents that are not married but co-parent, are we automatically co-guardians, or will one be appointed and the other parent appointed alternate?
Okay, there's no such thing as automatic. There's nothing automatic about this process. Anybody who wants to be a guardian has to specifically request it from the court. So if one parent is asking to be guardian, but the other parent is involved, they just never asked to be guardian, the court's not going to appoint the other parent guardian. Only the person that's asking to be guardian is going to be appointed. But there's a lot of different arrangements that you could make. You could have that, let's say one parent is more involved and the other parent is involved, but not as much. You could do that one parent is the guardian. You could do the other parent as the standby. You could even do an alternate standby. You could do co-standbys. There's a lot of different combinations to be worked out, but nothing is automatic. You have to specifically request these appointments from the court, and the court has to specifically approve them. Okay, is there any other questions that anybody has?
Is the guardian financially responsible for the child?
You're welcome, Mr. Butler. Is the guardian financially responsible for the child? Great question. This actually comes up a lot. The guardian is not financially responsible due to the guardianship. The guardianship does not cause somebody to be financially responsible. But if this person is the parent, I don't know what their exact obligations are once their child turns 18, but what do you say? So there are certain requirements for parents to have to support their child up to a certain age. That's a separate requirement. Those are separate from the guardianship. But just because you're appointed somebody's guardian, right? Let's say it's not the parent. Let's say it's the great aunt. Let's say it's a very close neighbor who's appointed guardian. There's no additional responsibilities that you really have, but you just now have this power to be able to make medical, financial, and personal decisions on behalf of the individual, but you're not financially responsible. So let's say the individual gets a speeding ticket, or let's say they get some kind of bill that they have to pay, it's not that, if somebody may call up the guardian and say, you have to pay this, but it never becomes the guardian's personal financial responsibility. Nobody's gonna go into the guardian's bank account and say, you personally have to pay this bill. That, none of that individual responsibility. Okay, so last call. Does anybody have any questions? You're also welcome to call or email the firm. Can we get the last slide up, or should I just repeat the information again? For the contact information for anybody who didn't catch it before. Okay, we'll leave up the slide for a couple of minutes. This is my name, my email, and are they able to see that? Okay, and that's my direct phone number with extensions on the bottom. Let's just check the chat one more time. Just want to see if anyone has any other questions. Okay, no other questions. Okay, thank you, everyone. Have a great rest of your day. Happy Wednesday. Thanks for listening.